Mr. Short.
My lady. I'm going to deal with grounds 3 and 4 in the next 45 minutes. I'll spend almost all of that time on ground 4, but ground 3 is a short point which really follows on from ground 2. It arises from paragraphs 184 onwards of the judgment, which are from page 232 of the main of the core appeal bundle. 184, having expressed his conclusion on the causation disadvantage point, Justice Choudhury says, even if that's wrong, there's a disparate impact which is causally linked to the PCP. The particular context in which that disparity arises, namely pension schemes, provides a weak starting point for a claim of age-related discrimination, and then deals with a case, Crown on the application of Harvey, which itself deals with the Gurung case at page paragraph 187 within the quote. The gist of both of which, I think, is that it is commonplace for schemes to introduce new sets of benefits from a particular date and fall in one side of the line or the other is unlikely to give rise to a powerful age discrimination claim. The learned judge's conclusion at paragraph 187 is, in these circumstances, the need for justification does not arise, notwithstanding any disparate impact, or if it does, justification is readily made out. The first proposition there is wrong for what it's worth. It's still necessary to consider whether there's justification, albeit that the second part, justification is readily made out, may well be right in cases that do just involve the introduction of a new regime from a particular date for new members, new employees. But that's not, in my submission, the case here, for the reasons really that I sought to develop under ground 2, which is that this was about the introduction of a new rule that had a disparate impact for another reason, rather than simply the introduction of a new regime. Now, it is obviously the case that pension schemes are inherently linked to age, and they are intended primarily to provide benefits for old age, and it is inevitable that some rules are related to age and are going to be vulnerable to challenge for that reason. So rules that stop members accessing funds before a particular date, or rules that adjust the amount that's paid if it's paid before or after a normal retirement date, won't require justification. They tend to be excluded under the legislative scheme, but would be readily justifiable anyway. And likewise with closing dates. But that doesn't mean that any rule, age-related or not, whatever it does, is necessarily easily justified in relation to age or the other protected characteristics, and that is demonstrated by the McCloud and Sargeant cases themselves. So if this was a complaint about the start date requirement, then the approach set out in the second part of the paragraph would be correct, but in my submission it isn't that case, and the approach taken at paragraph 187 is wrong. Ground 4 will require more exposition, and it deals with the extent to which a desire to avoid cost, budgetary reasons, can provide justification for something which would otherwise be discriminatory. And the principle that a desire to avoid cost cannot provide justification for indirect discrimination has been well established for 30 years. Now, there's no real issue here as to the underlying facts. The issue is to the characterisation of those facts. But it is worth, I think, looking at the respondents' summary grounds of resistance, which are in the core bundle at page 368. And the case is set out very clearly. So it's only dealt with in the summary grounds of resistance, the detailed grounds of resistance, which I think are shorter, don't duplicate this response, they don't depart from it. But it's paragraph 44.1.2, and says, Her Majesty's Treasury at the time, Treasury now, is pursuing the public policy aim of limiting the costs of the scheme, and specifically the uplift in the value of members' benefits to taxpayers. Pausing there, that, in my submission, is purely a budgetary reason. It's a desire to limit costs. Goes on to say, rather, it's not really about saving costs, rather it's about how the burden should be allocated between members, employers and taxpayers, ensuring a fair balance of risk between members and taxpayers has always been a core aim of the cost control mechanism.
I was going to say, Mr. Short, it's not really a avoiding cost or limiting cost, it's allocation of cost, isn't it?
Well, it is avoiding costs in the sense that they say we, as whether that's the government or the taxpayer or the public sector employers, it's the same thing. They say we do not want to have this cost. We do not want to bear this cost. We want someone else to bear it instead. And that is, in my submission, a limitation on costs, budgetary reasons for the purposes of this principle. The fact that they want someone else to pay it is just about limiting the costs to the taxpayer, costs to the government, however that's characterised. But there is no difference in my submission whether one's talking about withholding a benefit or imposing a burden. Both of those things are subject to the same rules on cost. Now, here, I've made a point in passing earlier that although there's a reference to the cost of the taxpayer, it's no different in many ways to an ordinary indirect discrimination claim where the impact is falling, where the costs are those of the company, the employer, because actually that may really mean the shareholders of the company or people who get profit-related pay or something of that nature. But there is a long-standing line of authority that deals with whether budgetary reasons, and this is without doubt a budgetary reason, can provide justification. Now, it's dealt with in the judgment from page 235 onwards, at paragraph 189, and the decision really appears at 191, paragraph 191, 238, where the judge says it isn't a fair characterisation to say this is just costs or solely about costs. It's about affordability, sustainability, etc. And in our submission, that is an error because this desire should have been characterised as an impermissible cost modification. The cases start with a decision of the Court of Justice called De Veerd, which is in the main bundle of authorities at page 67.
Sorry, so main bundle of authorities.
Yes.
At?
It's tab 2,
Thank you.
page 67. And your ladyship will see it's called M.A. De Veerd knee rocks. And in some cases it's referred to as rocks rather than doing. It's the same case. And this was a social security case. And importantly, it was an indirect discrimination case. Because at this time, it was not possible to justify direct discrimination. That possibility as a matter of EU law, and indeed as a matter of domestic law, came in later with age discrimination and with quasi-discrimination claims based on part-time and fixed-term work.
To what extent are the provisions in the Equality Act implementing EU regulations, and to what extent are they purely domestic?
The indirect discrimination provisions are modelled on EU law, and in Baroness Hale, when she tracks through the history of indirect discrimination legislation, points out the similarities between it began. Domestic law began quite narrowly in its definition of indirect discrimination, but it was, I think from 2003, amended to match the EU approach. So, for example, particular disadvantage is a concept that was drawn from a directive. But they did give effect to EU law. The facts involved benefits, so it's not an employment case, and in particular there was a qualifying requirement for one benefit that there should have been earnings in the previous year, and that had an indirect impact, or I'm sorry, that had a disproportionate impact on women. For reasons of childcare and the like. So it's a quintessential indirect discrimination claim, and at paragraph 31, which is at page 79 of the bundle, the court introduces the question whether the Article 4 of the Social Security Directive includes the application of national legislation which makes the grant of benefits for incapacity to work dependent on the requirement of having received some income during the year preceding the commencement of incapacity, a condition which, although it does not distinguish on the grounds of sex, affects far more women than men, even if the adoption of that national legislation is justified on budgetary grounds. And at 35 to 38, the court answers that in the negative. And really, I simply ask the court to read those paragraphs. Now, these are, in my submission, the the key paragraphs, because these are the paragraphs that are relied upon by the Supreme Court in the O'Brien case, which was about fee paid judges' pensions. And the gist of what they establish in my submission, I'll come on to O'Brien, is that they establish, although a national state can rely on budgetary considerations to decide how much it will spend on a particular thing, it cannot decide how the allocation of benefit or burden within that framework is to be arranged in an indirectly discriminatory way by reference to budgetary considerations. So that is the essence, in my submission, of this case. And I say that the directions, the cost control mechanism, is really a De Weerdt case rather than a Hill and Stapleton case. Certainly it's not a managing the budget case, such as was being considered by the Court of Appeal in the Heskett decision that I'll come on to. I'll refer to Hill and Stapleton. Now that's in the bundle, the main bundle behind tab 3. It begins at page 85. This was a case where people who had been part-time workers and then went full-time suffered a disadvantage. Again, it's an indirect discrimination case, and that was done for cost reasons. And here the Court of Justice said, paragraph 40, which is at page 107, so far as the justification based on economic grounds is concerned, it should be noted that an employer cannot justify discrimination arising from a job sharing scheme solely on the ground that avoidance of such discrimination would involve increased cost. And that was the approach that's really focused on in the Heskett case, which we'll come on to, and by learned judge in this case. Now, at tab 2 of the core bundle, and I think I'm going to stay in the core bundle, I think, from now on, we have the Supreme Court's decision in Ministry of Justice against O'Brien. And this is, the judgment is a judgment of the court, although it was handed down by Lord Hope and Baron Hope, but it's a judgment of the court. And much of the judgment concerned the question of whether fee-paid judges were in an employment relationship or not. And I needn't concern us, but at page 85 of the bundle onwards, the court turns to the question of objective justification. The Part-Time Workers Directive, like the Fixed-Term Workers Directive, Fixed-Term Work Directive, is unusual in allowing the justification of direct discrimination against part-time workers. And at 44, says there is, however, little guidance from the Court of Justice as to what might consider such, what might constitute such objective grounds, other than that which we have been given in this particular case, the decision of the ECJ on a reference in this case. And they set out at 64, 65, 66, the relevant extracts from the decision of the ECJ in these cases. And at paragraph 66, the Court of Justice says it must be recalled that budgetary considerations cannot justify discrimination. See to that effect, Schoenheit, Star Frankfurt, and Lanz and Tirol. It doesn't refer to De Weerdt expressly, although Schoenheit does refer to De Weerd, and the word one can see is the same as that in De Weerd. At 49, the ministry sets out the ministry's three arguments on justification. The first two don't concern us, but three is to keep the cost of judicial pensions within limits which are affordable and sustainable is, in my submission, really indistinguishable from the justification in this case. And that part of the objective justification defence is considered from paragraph 63, page 90, onwards. And this, here the ministry accepted they couldn't justify discriminating against part-time workers on cost alone, but said it was a cost plus case, i.e. there was something else made it permissible, and the Supreme Court said it was a subtle point, not without difficulty, a comment with which Lord Justice Underhill expressly agrees in Heskin. But they start off at 64 by saying the starting point for the discussion of this issue is De Weerd. And set out paragraph 35, which the court has seen, and then says, in other words, richer states may have more generous benefit systems than do poorer states. Cost may inform how much the state will spend upon its benefit system, but the choices made within that system must pursue policy aims other than the saving of costs. And then having set out paragraph 36 of De Weerd, it's one thing to set benefits at a particular level for budgetary reasons, it's another thing to pay women less than men because it's cheaper to do so. Sex discrimination is wrong, whether the state or the employer is rich or poor. I'm pausing there. Given the reference to De Weerd, that cannot, in my submission, be limited to direct discrimination because the case referred to, and this principle is one relating to indirect discrimination, and there's no question of justifying direct sex discrimination. 65 says, but say the ministry, the fact that the social policy aim is affected by budgetary considerations does not invalidate it if it is otherwise justified. Their best case was one pronounced as Jurgensen, and in that case there was a rule which meant if someone, a specialist rheumatologist, sold her practice, its turnover would be such as that it would be treated as a part-time practice and subject to a cap on the fees. So on that basis it may well be, in line with experience of part-time work, something that would have an adverse impact on women, and she argued that this was indirectly discrimination on the grounds of sex because her lower turnover was a result of her domestic responsibilities. But the aim of the scheme, which imposed the cap, was to limit the exercise of part-time specialist practice, it being considered that many doctors who work principally in the hospital and part-time in their own practice neglected the former for the sake of the latter. So that's plainly not a cost-related reason. And at 66, the Court of Justice gave their answer, or it refers to the answer of the Court of Justice, set out at the bottom, page 91, budgetary considerations cannot in themselves justify discrimination on the grounds of sex, indirect discrimination, measures intended to ensure sound management of public expenditure, specialised medical care, and guarantee people's access to such care may be justified if they meet the other parts of the test. So that case reasserts basic principle that budgetary considerations cannot in themselves justify indirect discrimination. 67, the Supreme Court said, well, that hadn't taken them very far. Sound management of the public finances may be a legitimate aim, but that's very different from deliberately discriminating against part-time workers in order to save money. There's reference to the European Commission against the Netherlands, and here it was the focus of the complaint was a residence requirement upon migrant workers and their families for eligibility for student support for courses outside the Netherlands, which was said to breach the principle of non-discrimination. And the Netherlands argued that the requirement was necessary in order to avoid an unreasonable financial burden, and the court reiterated, the ECJ reiterated in paragraphs 57 and 58 the principles in de Weerd, and as Advocate General Sharpster had put it in her opinion, and here the Supreme Court seemed to be agreeing with this, any conditions attached to the scheme in order to keep expenditure within acceptable limits must be borne equally by migrant workers and Netherlands workers. And that has, in my submission, a resonance for this case, because the burdens here were not being shared equally between the older and younger cohorts. So there's nothing in 68, I think, that I want to emphasise, but then 69, the same point. European cases clearly establish a member state will decide for itself how much it will spend on its benefit system, presumably upon its justice system or indeed any other area of social policy. But within that system, the choices it makes must be consistent with the principles of equal treatment and non-discrimination. And in my submission, that's what didn't happen here, because the burden of paying for the consequences of the discrimination inherent in the schemes originally drawn up, the burden was allocated in a discriminatory way because the government didn't want itself to meet any part of that burden. And that is, in my submission, the clearest budgetary consideration and is inconsistent with the principle as identified in de Weerd, the cases since then, and Ministry of Justice. Now, in their conclusions, the Supreme Court, and this is from paragraph 71 to 74, they say, in effect, the arguments presented to us are the same as the arguments presented by the Kingdom of the Netherlands, the European Commission against Netherlands, in that if recorders get a pension, then the pensions payable to circuit judges have to be reduced. That's a pure budgetary consideration. It depends upon the assumption that the present sums available for judicial pensions are fixed for all time. Of course, there is not a bottomless fund of money, public money available. Of course, we're currently living in difficult times. Fundamental principles of equal treatment cannot depend on how much money happens to be available in the public coffers at any one time, or on how the state chooses to allocate the funds available between the various responsibilities it undertakes. That would not avail a private employer, should not avail the state in its capacity as an employer. Even supposing that direct sex discrimination were justifiable, it would not be legitimate to pay women judges less than men judges on the basis this would cost less, that more money would be available to attract the best male candidates, even on the basis that most women need less than most men. Now, that passage in particular was relied upon by the unsuccessful appellants in Heskett, and Lord Justice Hunter said that didn't apply to the case before him. But in my submission, we'll go to Heskett now.
Sorry, before you leave this case, sure, can I just ask you a question about paragraph 70, please? Last couple of sentences of that paragraph, Baroness Hale says that Court of Justice. Is that still the position? Given that United Kingdom's left the EU.
Yeah.
I mean, I don't know the answer to that. I'm just asking.
Yes, I think still the position.
Is it retained EU law or something?
Yes, for the purposes of it. If something new happened today, then it might be a different answer. But this is about something that happened in 2021 within the 3-year period.
Oh, I see. Yeah.
And so it's affected by the EU Withdrawal Act and the transitional provisions rather than the Retained Law Act,
Right.
which says anything from 2003 onwards is not affected in the same way. So this is still under the same regime.
I'd forgotten that we're talking about something that happened a while ago.
Yes. But in pensions terms, lightning speed.
No, I was going to say.
Just blink of an eye ago.
3 minutes ago.
But there we are. But
Thank you.
yes, but yeah, Heskett isn't about. Ministry of Justice was about government setting up a pension scheme, saying it goes this far, it doesn't go that far. We're going to allocate the benefit and the burden in that case, allocate it in this way. This case is about allocating the burden of particular aspects. Heskett, my submission, which is at page 220 of the core bundle, dealt with an employer, had a pay scale, pay progression, which as a result of wage restraint was altered so that people progressed less quickly up the scale, so it had a particular impact on younger employees. And the question was whether it was justified. And Lord Justice Underhill, he gave the leading judgment, went through the authorities, more authorities than I touched upon, from paragraph 45 to 79. That's page 233 onwards. I'm not going to revisit that, but it sets out the jurisprudence in great detail, and then analyses those cases and their impact on his case, the case before him and his colleagues, from paragraph 79 onwards. Paragraph 79, which is at page 244, identifies or comments upon the difference in the language used in the De Vered line of authorities, which talk about budgetary considerations, and the Hill line solely to increase costs. He said, Lord Justice Underhill said, although Mr. Justice Burton attached importance to the distinction in cross, which is where an old case referred to in this judgment, where the Employment Appeal Tribunal said, well, De Vered's about central government and budgetary responsibilities, and Hill is about employers and solely about costs. But in this case, Lord Justice Underhill says, I do not in fact believe that the distinction is significant, at least in this appeal. But the CJ's use of different language was clearly deliberate, and in what follows, I will use the language Hill. And it certainly wasn't ruling out there being a difference in other cases, and in my submission, that's quite important here. he was dealing with a case where an employer was required to balance its books by a greater power. He was not dealing with a case such as O'Brien or this case, where the respondent was the greater power and was deciding how much could be allocated in any particular area and who would bear the burden. Paragraph 94 Lord Justice Underhill says that Ms. Darwin relied on 3 cases which she said established it was legitimate for an employer to take terms to ensure that it lived within its means. He took them in turn. One is Land Registry and Benson. One is ED against HCL Insurance. One is a police case called Harrod. But what unifies them is they are all exactly that, and that's set out at paragraph 98, the last 4 lines. Lord Justice Underhill says, nevertheless, there affords some support to the proposition that an employer's need to reduce expenditure and specifically its staff costs in order to balance its books can constitute a legitimate aim for the purposes of a justification defence. And I say that is not this case. At 99, he says, more importantly, I think that proposition is correct in principle. Nothing suggests that CJEU in Hill, Kutzbauer, Steinecker had in mind a case of the present kind, where an employer is having to make choices about how best to allocate a limited budget. Justification advanced in those cases was purely that avoiding discrimination would cost more. So pausing there, Lord Justice Underhill is very much focused on the case of the present kind, which was an employer balancing the budget it was given. 101, I do invite the court to read the judgment as a whole and in context, but judgment, paragraph 101, he said, I recognise it may sometimes be difficult for a tribunal to draw the line between a case where an employer simply wishes to reduce costs and cases where it is, in effect, compelled to do so. Again, that underlines the fact that he was dealing with a case where employers had been compelled to meet a budget. 102 then refers to the appellant's response, which was relying on paragraph 74 of the Supreme Court, and I've tried, necessarily in light of that, I'm relying on not just on paragraph 74, but on the earlier passages that say, although a state can decide how much it's going to spend, it can't decide to allocate that in a discriminatory fashion by reference to cost. And at 103, he says, I do not believe that passage is applicable to the present case or others of the kind which I have been considering in the previous paragraph. So the limit there is saying it doesn't apply to the cases where an employer is meeting a budget imposed upon it. Goes on to say, the court was concerned with a case of overt and deliberate direct discrimination against part-time workers. And it is, he goes on to say, slightly for time, we're concerned with indirect discrimination, more specifically a situation where the employer has altered its pay arrangements in a way which has a disparate impact on employers of different ages. As such, changes are very liable to do so. I see no sign that the Supreme Court had in mind a case of this kind. We're pausing there. A case of this kind is one identified at the start of 103, employers meeting a budget. Lord Justice Underhill cannot, in my submission, be taken to have said these rules only apply to direct discrimination cases, because they don't. That's not, it was never the position. this principle arose in indirect discrimination cases. And then, again, 104, a question was raised in the course of the hearing as to whether in cases of that type, whether one should consider the actions of the employer or the Treasury's justification for constraining the budget in the first place. And in the event, the court decided that wasn't necessary to consider, and the last 5 lines or so say, however, leaving aside the kind of case with which the Supreme Court was discussing at paragraph 74, this judgment in O'Brien, I would take some convincing it was illegitimate for a government department or agency to keep its pay budget within the limits imposed by the Treasury or a parent department. That was certainly the basis on which Benson was decided, and that is, in my submission, the basis upon which these cases were decided. And they are different to the present case, which is an O'Brien and a De Weird case, and depends on budgetary decisions to impose a burden on one group. Of course, it's not direct discrimination, neither is De Weird, but it did involve a deliberate decision to impose the burden on a group, knowing that to a large extent they would not benefit from the costs they were being required to meet, and knowing it would have a disproportionate impact by reference to age, other protected characteristics. And in my submission, that is not permissible, and the learned judge should have so found. Now that, if I can just take a moment. Unless I can assist further, those are my submissions on the grounds. I did say I would deal with a couple of, or try and deal with a couple of points. One is, I am told, to my learned friend, I'm told that the firefighters and the health AVRs for the next implementation period have now been published. We understand.
Sorry, you said AVR. Do you mean actuarial valuation?
Yes,
reports?
the reports.
Yeah.
The next reports have been published, and I understand, although I need to check this, I understand that the new versions take no account of any legacy costs, but again, we will check that. But we understand that to be the case.
Thank you.
I'm very grateful. Yeah, sure.
Ms. Morris.
Your Ladyship's Lordship, I represent the BMA. It's the trade union and professional body for doctors and medical students in the UK. It has more than 190,000 members, the vast majority of whom are members of the NHS pension scheme with which we're concerned today. We advance our appeal on 2 grounds. First, the judge erred in concluding that there was no duty to consult. And secondly, that he erred in finding that there was no failure to fulfil public sector equality duty in this case. Now, the judge also addressed the defendant's Section 31 defence in relation to both of these points. Now, depending on how timing goes, I'll either deal with that at the end of today or at the end of my timing tomorrow. We endorse the submissions that are made on behalf of the FBU and the other unions, and we advance our case as complementary to theirs. In terms of the way in which I'm going to organise my submissions, I'll take each ground in turn. I'm going to briefly outline our case, show you a few relevant factual matters under each heading, then look at the law, and then make my submissions in relation to the judgment. So starting with the consultation ground and the outline of our case under that heading. We say that there was a duty to consult in this case arising from the combined effect of the factors. On the one hand, assurances of involvement and discussion, and on the other, the contextual factors, such as the fact that there was consultation on a range of other issues concerned with the McCloud remedy, with which this topic could have been combined. The fact that this arose out of the need for there to be a remedy consequent upon McCloud, the numbers of people affected and the extent of the impact, and then the extent of the change from the original approach. Now, we say that in a case where there is such a mixture of factors which don't fit neatly into the Plantagenet categories, then it's wrong to treat Plantagenet as a cage rather than a guide. And we say that in that case, the court needs to look more broadly than simple conspicuous unfairness. In this case, we say the judge got it wrong by taking an unduly siloed and narrow approach. He looked at each element individually and not in combination, and then having excluded each one, said that there was nothing there to reach the necessary standard. But we say that he should have looked at all the factors together, whether as two sets or as a group as a whole. So just looking briefly at one or two items on the factual side.
Just pausing now, please, if I may. Is there any authority that supports this approach?
Lady, yes, I'm going to take you through the law in a minute. I'm going to show you, if I may, that the way in which Plantagenet was expressed was more narrow than the underpinning law that was referred to, and in particular, Bat Murphy. And indeed, there are other authorities which have shown and adopted that phrase, that it ought not to be treated as a cage rather than a guide. And so if I might, I wonder if it's convenient, though, for me to touch upon the factual matters first before taking...
No, sure. Because it just wasn't clear from your skeleton argument whether you were saying that Lord Wilson in Moseley was setting out a basis for a duty to consult, or whether you were just relying on the descriptive phrase conspicuous unfairness. So I just would like to understand that a bit more clearly.
Absolutely, my lady. I wonder if I can just lay down one or two bricks on the factual side before building a greater edifice on the law side, if I may. So just sticking with the facts, and just for your note, we deal with this at paragraph 8 following in our skeleton. The first item I'd invite you to look at in relation to the assurances is in the supplementary bundle at tab 4. And it's a Treasury policy document from 2012, and in particular, page 138, the executive summary, and what is explained there about the way in which these two types of costs will be divided within the mechanism. Now, that was followed by the document we have at tab 5. Which
I'm
is
afraid I don't have tabs in this bundle.
Oh, I do apologise.
That's fine.
Well, then the first document starts at 132,
So
and
this
the relevant...
is a document that precedes the legislation, is it?
Yes.
Right. And how is it relevant to...
Because they make assurances about how it's going to operate, my lady.
But that's not
So-
a tool by which we can construe section 12, etc., is it?
No, lady, but I'm not inviting you to rely on it to construe section 12.
Good.
What I'm inviting you to rely on it for is to look at the procedural promises, the assurances that were given about how changes were going to be made and how the scheme was going to operate.
Which is the bit on page 138 that you want us to look at?
It's the executive summary, my lord. And they talk about, you see at the beginning, the fair balance. And then the penultimate paragraph explains how the cost cap mechanism is going to operate and how changes in costs will be dealt with. So that's what, for example, members of the trade union, which I represent, was expecting.
But sorry, where does this talk about consultation?
Oh, not in that document, my lady.
Right. So,
But
for what purpose? I'm sorry to press you, but for what purpose are we looking at this document that precedes consultation?
It relates to one of the contextual factors which I've identified, lady, which is what was being expected in relation to the operation of the cost control mechanism.
So what it said was the cost cap will control all of the cost risks associated with new pension schemes and risks associated with active members who have service in legacy schemes. Is that on? I mean, do you take issue with that? I mean,
No. What I'm seeking to do is show you the foundation for what we say were the contextual factors which were material to the question of whether there was a duty to consult in this case. Because, as you'll see from the authorities in a moment, the question of whether there is a duty to consult is intensely fact sensitive.
Okay.
Then if you turn in the document that starts at page 146, and particularly page 155, paragraph 1.9, second sentence.
Sorry,
Page 155, paragraph 1.9. The Treasury will also involve other stakeholders when considering the approach to valuations. I do beg your pardon.
No, it's Mike. I said it's my fault. Just write page 155.
Immediately above the red heading.
Oh, I see. So this is another document that precedes the enactment of legislation, is that right?
Yes, my lady.
Okay.
November 2012.
Yes, your ladyship. And then in terms of what was expected, there's a reiteration at 1.16 and 1.17 about the division between the types of costs. Now, this was, as your ladyships and your lordship have indicated, that which preceded the 2013 Act and the regulations. Now, they were accompanied with guidance, which we have at tab 6, starting at page 164 for those of you without tabs.
I don't think any of us have got tabs.
Oh, I do apologise. I didn't realise I was in such a privileged position.
I've got tabs, but they were inserted by my clerk.
More privilege.
Yeah.
I know it's terrible to me.
Yeah,
So
you
we're at
should-
164,
Yes, please.
and this is March 2014.
Yeah, so this is the guidance which accompanied the legislation. And you'll, it again,
Sorry to interrupt again. Is this statutory guidance or non-statutory guidance?
non-statutory. And then if you look within this, page 183, paragraph 2.35. The last sentence. Now, in terms of what took place, we set this out. Oh, sorry, there's another reference at page 184, paragraph 2.41, discussion before changes. And so in terms of what took place, that's set out in our skeleton at paragraph 17 following. What we know is that McCloud judgment was handed down in December 2018. Then in January 2019, we have the document which is in the supplementary bundle behind tab 7, page 208. And this is from the Chief Secretary. Sorry, this is a Treasury document, and if you turn within it to page 209, paragraph 4, and that refers back to the preceding paragraph. It says briefly on C, you have previously given a steer that the costs of complying with the court ruling should be borne by employees rather than taxpayers. So that's what was being said in January 2019. Then the next thing I'd ask you to look at is at page 218 behind tab 9. And if you look at the box at the top of page 218, there's a summary that refers back to the ruling of the Court of Appeal in McCloud. And then at B, it says, we should look again at the generosity of the schemes to ensure costs are sustainable. We're currently working with the departments and actuaries to develop a firm proposal on A. This note seeks views on B, where there are a range of options ranging from tweaking existing features of the current framework to wholesale reform of pension schemes. And then if you turn on to...
Sorry, so this is an X. What is this document?
Oh, sorry, I've just turned away from it now.
No,
And tab 9. This appears to be a Treasury document. Then we have some slides which appear to have been produced at the same time that start at 261, produced by the Treasury. McCloud response, litigation and trades union handling. And then if you turn to the last page of those slides and the box on the left-hand side.
Where are the slides?
230. The same language is used there. Tweaks to existing framework, e.g. including McCloud remedy costs in the cost control mechanism.
I'm sorry, I can't see that on page 230, and I'm... Oh, in the... Of course, because actually it's highlighted in the box.
Oh, I...
Sorry about that.
That's quite all right. And so the next document to which I'd invite your attention is over the page 231 behind tab 11. Then under the heading halfway down that page, summary, you need to decide who should bear the cost of the remedy for the McCloud judgment, public service employees or scheme members, which could be broadly achieved via the cost control mechanism. Recommendation, once there's certainty about the McCloud remedy, the cost control mechanism is restarted with the cost of McCloud remedy largely placed on members. Do you agree? And then options, over the page, B, place the cost on members by running cost control valuations and McCloud remedy costs including. And then at the bottom of the page, there's a heading which fleshes out that option. And we see that this is where a rationale appears, which differs from that which was articulated in the material which preceded the legislation. So you have three. Second sentence, when the mechanism was designed, we agreed it would only consider member costs, such as life expectancy assumptions. And then at 4, the government, in its policy statement in 2014, noted the possibility of unforeseen future changes in costs and set out that decisions about whether such changes should feed through the mechanism will be taken on a case-by-case basis, balancing interests. And then the last sentence, the McCloud remedy clearly fits into the category of member costs. And so balancing the interests of members and other taxpayers, we recommend that members bear the costs of McCloud. So pausing there, we see at this very early stage, it was abundantly clear that the plan was to pass these costs on to members. And then a justification emerged which related to essentially a redefinition of what was a member cost, which was a change from that which had been represented before the legislation.
Can I just explore that a bit? Because
Yes.
I've not quite understood that point. The initial division into member costs and employer costs distinguished between things like longevity and salary, which were member costs, and things like financial assumptions, which were employer costs. Now, one way of characterising that division is that member costs tell you how much pension you're going to have to pay, and employer costs tell you how much money you need in order to fund those liabilities. And if you divide it, characterise it that way, you can see that what you have to pay members under McCloud are member costs, because they affect the quantum of the liabilities that are going out, not the amount of money needed to fund them. So why do you say it's a change from the original division into member costs and employer costs, which never pretended to be exhaustive, gave examples of member costs?
Your Lordship, I have two responses. One is to pick up the thread first pulled by your ladyship this morning, which is that this was a remedy for a civil wrong, and in that case it isn't reasonably characterised as an employer cost in the sense that your Lordship has suggested. But secondly, we say that it was in any event too far from that category, and perhaps thirdly, even if it was something about which, as we say, there should have been a dialogue. And there was no dialogue. As we can see, there was simply an announcement that it clearly fits. So what
I wrote down is that a new justification emerges with a redefinition of member costs. And that suggests there was an original definition and there's now been a departure from it. But could you explain what the original definition was and why this is a departure from it?
Your Lordship, I'd refer back to the material that I showed you just at the outset. You're right, Your Lordship, to tax me on the issue, but of course it remains the case that our ground is concerned with the decision-making process rather than the conclusion. And what I'm seeking to show the court here is that the way in which the decision was made was essentially a decision was made to transfer the cost to members. Then we can see from the documents that a justification for it was advanced, which is the document I've just shown you. And it was only later when there was a discovery on the part of those affected what was going on that they raised questions about it. But at no stage was there anything which merited description consultation. And where a decision of this magnitude was going to be made, it was one that required consultation.
Well, I understand all that, but I've not understood the point you made that it was a redefinition. What you showed us was at page 138.
Yes.
And that distinguished between changes in costs arising from technical or financial changes, changes in costs which directly relate to members. And then it gives some examples.
Yes.
Well, this change, McCloud, is not a technical or financial change.
Well, Lord, we'd say it was financial or technical because it related to the operation of the scheme, and it was if it was going to fit under either of those definitions, it was aligned much more closely with that than it was a changing expectation about life expectancy, salary growth, or career path. Those were typically very personal factors. This was, in one sense, a structural change in the pension scheme rather than a personal change. And that's why we say what we see at 233 is effectively a redefinition of what a member cost is.
Okay.
The member cost is something personal about individuals. There is nothing in the McCloud remedy which fits within that definition.
And am I right to think that you rely quite heavily on paragraph 3 on page 233, which says, in effect, that whilst the past service costs of transitionally protected members were included, future service costs of transitional protection were not, on the assumption that there weren't going to be many, it'd be fine. And that's been proved wrong. So you're saying, are you, that there is an explanation which says we carved this out and now we're putting it in?
Exactly, my lady. That there was a particular approach was taken. Representations were made about it. There was a decision to pass the cost taken, and this is the first point at which we see a justification. And we say that it does involve what is a shift, and perhaps yes, my lady's right to say that the shift is demonstrated by suggesting that the McCloud judgment disproves the mechanism, which it can. That's hardly a fair description of the effect of the judgment, we would say.
No, it didn't disprove a mechanism, it disproved an assumption about the scheme. Isn't that what paragraph 3 says?
Disproves the assumption that there wouldn't be many and that would be fine.
So that's what it disproves.
Well, if we...
It disproves it because the McCloud judgment shows that the transitional protection that was provided was inadequate and discriminated on grounds of age.
I rather doubt that the judgment amounts to proof, does it? It's a matter of a legal change rather than a matter of evidence.
Well,
Yeah, but it shows that an assumption that had been
the
made
assumption was wrong.
was wrong. That's what the author of this paragraph means. He means we assume that transitional protection was a very limited problem that would rapidly fade away. And McCloud shows we were wrong about that because actually we have now got to give the McCloud remedy to many more people for a much longer period. That's effectively what's being said.
But even if it's the case that that is being said, we submit that it doesn't turn it into a member cost of like kind of matters such as life expectancy or expectation of salary growth, which are personal member characteristics. That's still a structural financial feature of the scheme rather than a personal element of the scheme. But of course, bearing in mind that our ground is a procedural ground, these are all debates which should have been had through consultation. But effectively, as you can see from the decision-making process, there was no such dialogue because bodies such as those whom I represent were locked out of the process. So the next document you were taken to briefly by my learned friend this morning, and it starts at 237. Another Treasury document. At the bottom of the page, there's a heading, recommendation. So we propose that several changes are made to the directions in order to capture the majority of remedy costs. Then over the page at 238, there's a heading, background, and it says, in April, you made 2 decisions. And the second one at B is that McCloud remedy falls into the category of a member cost. So what this document tells us, we submit, is that a decision was made at that point. And then you see at the top of the
That's April 2020.
Yes. And we say there's no ambiguity in the language there. And if you go to the top of the next page, second sentence, to capture the majority of the remedy costs in the CCM, so that's their purpose, changes are required to the direction. So the changes were made in order to pass those remedy costs on to employees. Now, my learned friend showed you something at page 241, which referred to a public sector equality duty assessment. I just want to mention there that that assessment didn't relate to this issue, the one which I'm taxing you with today. It related to another aspect of the process. And indeed, we've never even been shown that assessment. Then if we can go to what Mr. Justice Choudhury then went on to call the in principle decision, we have the July 2020 written ministerial statement, which starts at page 249 behind tab 13. And halfway down page 250, there's a heading, Cost Control Mechanism Update. And then I just invite you to read the last paragraph on that page.
I'm so sorry. My fault was I was writing a note and I've listed your next page reference.
No, it's quite all right. Tab 13, page 249 is the start of the document, and the key bit is the last paragraph on page 250.
Thank you.
Our case is that wasn't an in principle decision, it was the decision, and nothing by way of involvement, discussion or consultation took place as it should have done. Now, in terms of what then took place afterwards, we summarise this in our skeleton at paragraph.
I'm so sorry. So this document is a written statement by the
Yes.
Treasury.
Yes. I'm in a... and just for your note, Mr. Justice Choudhury refers to it as the in principle decision at paragraphs 207 to 209 of his judgment. To look at that in a moment. So turning to then what took place as between bodies such as those whom I represent and government. As I've indicated, as soon as that became public knowledge, those bodies raised the issue of their own motion. But we say even if there was information flowing from trade unions to government, there was no dialogue and there was no conscientious consideration. And I'd invite you to look at the witness statement of Mr. Elks, which is relied upon by the respondent. It's in the supplementary bundle at tab 2. And I'd ask you to look at page 139.
So sorry, just before we leave page 250, what's the published consultation that was published on the 20th of July, which is referred to in that paragraph?
That's one of the other consultations on aspects of the McCloud remedy. I think that was the consultation about whether it was going to be, whether it's a deferred choice or not. So there was consultation taking place.
Right.
It just wasn't about this.
Okay.
And you've just taken us to page 139.
I think you might have meant paragraph 139.
I
exactly.
apologise.
It's just a blank page.
Oh yes, it's page 73,
Thank you.
paragraph 139.
Oh.
No, is that the wrong?
Um,
No, 145. I apologise. It's page 76, paragraph 145. So supplementary bundle, page 76, paragraph 145. This is the witness statement. So the trade unions were saying, we're troubled about this. I'm trying to take this as quickly as I can. But this is what the government says about what they were saying. We say, no way is this involvement, discussion, or conscientious consideration.
And it seems as if it's, well, they would say that, wouldn't they? And we didn't accept what we knew they'd say if they said it.
Pretty much.
Can I be sure I understand this? You've not shown us anything in which there was an express promise of consultation using that word. What you've shown us is statements that stakeholders will be involved and will engage with people affected and that sort of thing. Looking at Mr. Elk's witness statement, he says that there were a series of meetings with trade union representatives over the course of September 2020. That's in paragraph 144. And at those meetings, views were expressed that the McCloud remedy cost shouldn't be included. Why is that not a fulfilment of the promise to engage with those affected and to involve stakeholders?
If one looks at it from through the prism of involvement, engagement, discussion, we say precisely what my ladyship has said, which is that's saying, well, you would say that anyway, and there's nothing you can say that will change our mind. It has to be looked at as well, my lord, in the context of what I've just shown you about the decision-making process, which is their minds had been made up that this was a member cost and would be fitted into the CCM. So if this had been, we say, proper decision-making, there would have been a document saying, well, one possibility is fitting it into the CCM, another possibility is doing this, and there are various pros and cons. We're going to talk to the people affected about that before we make a decision. But there's nothing that fits that picture by any manner of means. There's an announcement, which we've shown you in July, doesn't allow for any alternative. Now, Mr. Justice Choudhury called that an in-principle decision, but we say that is a decision, and that's the context in which Mr. Elk's statement has to be read. But further, if I were able to satisfy this court that what was required by reason of those assurances, in addition to the contextual factors, and I'm going to come on to that in a minute, then in fact what there was a duty of consultation, and certainly there's nothing there that reaches the threshold for meeting the gunning criteria, specifically conscientious consideration. We say that what Mr. Elk says falls very far short of that.
Thank you.
And then just for your note, to put a little bit more colour on the way in which attempts to raise the issue were addressed, if I can invite you just to take a note of the witness statement of Mr. Shah on behalf of the BMA. That's behind tab 1. It starts at page 3, and the key paragraphs are 64 to 66. I'm not going to read them now. Now, I've mentioned to the court that there were other consultations going on. There are references to those in the bundle, but I'm hoping that I don't need to show you those, and I can start now on the law. So I'd invite you to take up the core bundle of authorities and look at the decision in Plantagenet behind tab 3. That starts at page 95. It's a judgment of the court comprising Lady Justice Hallett, Mr. Justice Ousley and Mr. Justice Haddon Kane, when Lady Justice Hallett was Vice President. And the key paragraph is paragraph 98 at page 115. Now, what paragraph 98 says is this. It starts with, the following general principles can be derived from the authorities. Now, no general duty to consult at common law, no dispute about that. And then 2, there are 4 main circumstances where a duty to consult may arise. First, where there's a statutory duty. Second, where there's been a promise to consult. Third, where there's been an established practice of consultation. And 4th, where in exceptional cases a failure to consult would lead to conspicuous unfairness. And then a strong statement is made, which we say has been read, and in some cases, and we say it goes too far. It says, absent these factors, there will be no obligation on a public body to consult. And there's a reference back there to Cheshire East, which I'll show you at paragraph 72, and I'll show you that in fact that's not what Cheshire East says. But that's the problematic sentence, first of all, that it's articulated as 4 main circumstances at the beginning of the paragraph, but by the end of the paragraph it's become an exclusionary rule. Then at 3, the common law will be slow to require a public body to engage in consultation where there's been no assurance either of consultation or so forth, and a reference back to Murphy. Now we say that's right, there will be slowness, but there shouldn't be an exclusionary rule. And then at 7, over the page, the common law will supply missions to the legislature by importing common law principles of fairness, good faith and consultation where it's necessary to do so. Then 8, where a public authority charged with the duty of making a decision promises to follow a certain procedure before reaching that decision, good administration requires that it should be bound by its undertaking as a procedure, provided it doesn't conflict with the authority's statutory duty. And so I say, from that proposition, what we're concerned with is a promise of a procedure. It's not just a promise of consultation. A promise of involvement, engagement, or discussion is just as much a promise of procedure. And then 9, the doctrine of legitimate expectation does not embrace expectations arising merely from the scale or context of particular decisions. Now, we say that properly read, that isn't to say that scale and context can never be a reason for a need for consultation. It's simply that it won't, it's on its own, it's not enough. And so we say that Plantagenet was not correctly applied, and I'll show you in a minute. So if we compare that with Mosley, and we have that behind the next tab, decision of the Supreme Court, and the key parts of it for our purposes, it's Lord Wilson at paragraph 23. Duty to consult can arise in a variety of ways, most commonly, as here, duty generated by statute, not infrequently, however, generated by the duty cast by the common law upon a public authority to act fairly.
But what's the value of that general statement? Because Mosley was a case in which there was an express statutory obligation to consult, so there's no issue in that case about whether or not there was an obligation to consult.
Well, lady, we say it has value for 2 reasons.
Yeah.
Firstly, we need to read what was said about conspicuous unfairness, particularly in Plantagenet, as part of a wider context of the origin of the duty to consult. And I'm going to show you in a minute Bat Murphy and Awazora to show you how that fits together. We'd say that the overarching principle is as articulated in Moseley, i.e. fairness. It's essentially what variety or level or flavour of fairness we're concerned with.
So
Now,
can I just ask you a further question before we leave Moseley? Lord Reed didn't wholly adopt the same analysis as Lord Wilson, and Baroness Hale and Lord Clark agreed with both judgments. So where does that leave us?
well, my lady, if I can invite your attention to Lord Reed at 35, paragraph 35.
Yeah.
The common law imposes a general duty of procedural fairness upon public authorities exercising a wide range of functions which affect the interests of individuals, but the content of that duty varies almost infinitely depending on the circumstances.
Yes,
And-
and next sentence, no general common law duty to consult.
Yes, my lady, there is no general common law duty to consult. The question is always whether in the circumstances of a particular case that duty arises, and in answering the question of whether it arises in a particular case, a judge must be careful not to treat, for example, the propositions as they were articulated in paragraph 2, paragraph 98.2 of Plantagenet, as a cage rather than a guide.
Sorry, so are we talking about a duty to consult, or are we talking about a duty to act fairly? I just want to understand what the submission is, please.
The overarching proposition from which all of this derives is a duty to afford the individual or groups of individuals procedural fairness. Within that, there are various obligations which will, the nature of which will derive from the particular factual circumstances. Here we say there was a constellation of factors, some of which amounted to the procedure obligation reflected in subparagraph 8 in Plantagenet, and some of which fell under the conspicuous unfairness heading. And the judge should have looked at them all together rather than siloing them and splitting them off in the way that he did in order to exclude them.
But with what result?
He found that there was no duty to consult.
So sorry, all I'm trying to do at the moment is to understand whether your argument is there's a duty to act fairly and the government didn't act fairly in this case, or whether you're saying there was a duty to consult and the government didn't consult. I just want to understand which of those two submissions you're making.
There was a duty to consult.
There's a duty to consult, okay.
May I ask you to look, please, at the judgment of Lord Justice Laws in Bat Murphy, and that's in the main bundle of authorities, tab 5. So it's a judgment of a Court of Appeal comprising the Master of the Roll, Lord Justice Laws and Lord Justice Sedley. And there is in it a careful review and analysis of the principles of legitimate expectation. And it starts, for our purposes, at page 168. And there's a heading there, legitimate expectations for principles. And just to pick out one or two key points before getting to the meat of it, at paragraph 27, second.
I'm so sorry to interrupt. Could you just give us a quick summary of what this case was about?
Yes, it's a case about the arrangements for compensation for miscarriages of justice.
Right. And what was challenged?
the scheme for making of payments. So, may I return to paragraph 27, my lady? So, legitimate expectation, its reach in practice is still being explored. So it doesn't have determinate parameters. At this point, His Lordship identifies that there are broadly two kinds, before going on in a minute to identify a third, who identifies procedural legitimate expectation, i.e. a promise of a process, and substantive legitimate expectation, i.e. a promise of a substantive interest. And then at paragraph 28, he says, either kind may arise in circumstances where a public decision maker changes or proposes to change, and such change is unfair or an abuse of process. And then whether or not it is fair depends on the circumstances of the case. Then at 29, he gives us the paradigm case. So this is the promise of consultation, which, of course, it's said against me isn't present in this case, and we accept that there was no express promise of consultation. But then importantly, at paragraph 30, there's this explanation of why the court will hold a public body to legitimate expectation, and it's the last third of the paragraph. It arises because good administration generally requires that where a public authority is given a plain assurance, it should be held to it. This is an objective standard of public decision making on which the courts insist. So for Lord Justice laws upon whom a great deal of the subsequent case law is founded sees the fundamental underpinning of this law as the need for good administration. Now, turning on within this, he then identifies at paragraph 35 just where the font changes, the importance for the application of rigorous standards. But it will be the court's own view of what fairness requires in a particular case. Now then at 35 he identifies this third class of legitimate expectation, and it is where there is a right to make representations before a substantive right is withdrawn. And he says that should be treated in the same way as procedural legitimate expectation. Now then at 40 he says what conditions are required for there to be such legitimate expectation. And then at 41 he says this, and it's a paragraph which is dissected in different ways in the authorities. Both types of legitimate expectation are concerned with exceptional situations because their vindication is a long way distant from the archetype of public decision making. Public authority will not often be held bound by the law to maintain in being a policy on which reasonable grounds it has chosen to alter or abandon, nor will the law often require such a body to involve a section of the public in decision-making process by notice or consultation if there has been no promise or practice to that effect. But then if you go on to paragraph 42, it's the other side of the coin. The court will insist on such a requirement, i.e. consultation, and enforce such an obligation, where the decision maker's proposed action would be so unfair as to amount to an abuse of power by reason of the way in which it's earlier conducted itself. And then he deals with the paradigm case of procedural expectations, generally unfair and abusive for the decision maker to break his express promise or established practice of notice or consultation. In such a case, the decision maker's right and duty to formulate and reformulate policy by its chosen procedure is not affronted, for it must itself have concluded that that interest is consistent with its proffered promise or practice. And then, of course, at the end, he says, what is fair or unfair is, of course, notoriously sensitive to factual nuance. and then at the end, the categories of unfairness are not closed, and this is a phrase which reappears. Precedent should act as a guide and not a cage, and that's a phrase which is repeated. What he then goes on to do at page 175, under the heading of the secondary case of procedural expectation, is give some examples of what that might be. And then there is a summary at paragraph 50. And then at paragraph 51, he then says, to all of this, there are no doubt refinements and qualifications. And then he returns to his core proposition at the end of that paragraph. The underlying principle of good administration, which requires public bodies to deal straightforwardly and consistently with the public, and by that token commends the doctrine of legitimate expectation should be treated as a legal standard, which, although not found in convention, takes its place alongside such rights as fair trial and no punishment without law. So that, we say, is the foundation of the question of whether consultation should be required in any particular case. Now, you'll remember that in Plantagenet, Lady Justice...
Sorry. So how are those principles applied to the facts in that case?
So in that case, oh sorry, I've turned away from it now. In that case, there was no finding of a legitimate expectation.
So is your case that there is a legitimate expectation of consultation?
The way that we put it, my lady, is that there was a legitimate expectation, consultation, or a duty of consultation, and it arose from procedural promises, namely the promises of involvement, engagement, discussion, and from the character of the surrounding circumstances, which we say engage the concepts of good administration as articulated by law, justice, laws.
So you're saying both. You're saying duty to consult and a legitimate expectation of consultation.
Yes, but my lady,
I just want to be clear what your submission is. I'm not being critical. I just
But-
want to understand it.
well, what we say is that the duty to consult, as identified by Lady Justice Hallett in Plantagenet, is founded upon the concept of legitimate expectation as articulated by law, justice, laws.
Right. So you're saying it's a duty to consult which arises from a legitimate expectation.
Yes.
Right. Okay. That's what you're saying. Okay.
So then if we have a look at Cheshire East, and we can see whether it is the foundation for the proposition advanced by Lady Justice Hallett in paragraph 98, subparagraph 2. Now, it's a judgment of Mr. Justice Langstaff. He refers back to the judgment of Law, Justice, Laws in Bat Murphy. We can see that at paragraph 56. But if we
Sorry, where do we find?
Tab 7 in the...
sorry, behind tab 7.
Thank you.
It's relied upon, as you've seen a moment ago, for the proposition that absent those four elements identified by Lady Justice Hallett, there will be no duty for consultation. But if you look at his paragraph 72, which is the one upon which she relies at page 223, that is not what is said there by Mr. Justice Langstaff. In the middle of the paragraph, he relies on law, justice, laws, and the general approach that was articulated there. It isn't an articulation of a restricted proposition. And in that case, like many of the others, he repeats the fact at paragraph 75, the top of 224, the determination of whether, albeit there was no promise to consult nor practice of it, the conduct of the defendant amounted to abuse of power insofar as it extended to denying the claimant's consultation, where fairness otherwise demanded it, is necessarily heavily fact-dependent. Fairness is to be judged overall and not examined purely from the perspective of the agreed, and then he looked at DEFRA's reasons for consulting. So we say that Cheshire East doesn't provide support for the narrow way in which things were articulated by, in paragraph 98 of Plantagenet. Now, behind tab 14, we have the case of Rainbow, which was relied upon by Mr. Justice Choudhury as an example of when it might be said that a duty arises. This is a decision of the Privy Council. And if you turn, please, to paragraph 51, page 396. What happens in this case is that there is a reflection on one of the examples given by Lord Justice Laws. This is between H and I in the paragraph. I, abruptness. But here it's treated as a necessary rather than a sufficient condition for there being the imposition of a duty of consultation. If you recall, when we looked at the examples, or indeed at the entirety of Lord Justice Law's judgment, nowhere was he suggesting that there were absolute rules. There was an emphasis on the need to look for fairness and it for it to be a judgment of the court based on all the facts of the case. But what appears to have been done by the Privy Council in this case is to treat one of the examples he gave, that of abruptness, and turned it into a necessary condition, which we'll see in a minute is something which was done by Mr. Justice Choudhury. And then just to draw, and then to just pick up another thread.
So what do you want us to take from Rainbow?
Well, Rainbow is a case which is relied upon by Mr. Justice Choudhury to give an example of the content of Plantagenet 4, i.e. conspicuous unfairness. But if one looks at Rainbow, what it does is wrongly, narrowly articulate that which is being said by Lord Justice Laws. And it turns what was an example, i.e. an abrupt change, into a necessary condition. And therefore I say it's not, it didn't bear, as I'll show in a minute, the weight which the learned judge put upon it.
What was that? Because it's a decision of the Privy Council, or
because the analysis, if it's said to be a correct articulation of the principles, and those principles are articulated as being those adumbrated by Lord Justice Laws, in fact, they don't accurately represent it. And so we say it's not a case which does the work for which Mr. Justice Choudhury relies upon it.
So in other words, you're saying the Privy Council inaccurately summarised the effect of the decision about Murphy.
Yes.
Right.
Then
Which is the bit in Rainbow where the Privy Council says it's a necessary condition?
It's paragraph 51 between H and I. You see the way that they take one of his examples.
Yes, abrupt changes. I mean, the classic case is Unilever.
Yes,
So you've got 20 years practice and the revenue just goes snap, and so you can't do it that way.
exactly.
But where do they say that you have to have an abrupt change before you can do it?
Well, it's this articulate, absent a representation that the policy would continue and abrupt change. So it's the use of that word absent again that appears to turn it into a necessary rather than a sufficient.
I'm not sure that I read that as them saying this is a necessary condition. But anyway, it may not matter.
My lord, it may not matter. Can I just briefly, I'm keen to get through
Yes.
this. May I ask you to look at the judgment of the Court of Appeal behind tab 26? For me, it's in the second volume of the main bundle of authorities. It's a decision of the Court of Appeal in, I'm not sure how to pronounce it, Azora. Vice President, Lord Justice Underhill, they just Rose and Sir Bernard Ricks, and then if I can invite your attention to paragraph 35, the way in which.
I'm so sorry, on 769 which tab, please?
26.
Thanks very much.
So if you turn within the judgment to page 758, there's a heading unfairness, second stage. If you turn over to the next page, 759, between B and C, when you see, in fact, between A and B, there's it says, although the judge dealt with questions of reliance and conspicuous unfairness separately, his analysis shows that factors the court takes into account at this second stage overlap and often do not fall neatly under different headings. There have been many different formulations of the test to be applied here because claims of legitimate expectation are made in greatly differing circumstances. The different ways in which the test has been expressed reflect the particular circumstances in which the issue has arisen, but they are all directed at the same high-level question. They all contain the same key ingredients. A representation made by the public authority, followed by conduct on the part of that authority vis-à-vis the claimant, which contradicts that statement and about which the claimant is aggrieved. The question for the court in each case is whether the failure of the public body in its conduct towards the claimant to abide by the representation it made is something which the court should intervene to prevent. The safest course in any particular case is not, therefore, to pick out passages from earlier authorities dealing with different circumstances and attempt to transplant them into a different situation, but to consider what factors should be relevant in answering the fundamental question, guided by earlier cases in which the facts were reasonably close to the facts facing the court in the state case.
So what's the fundamental question?
It's the question, we say, of fairness. You can see the heading in that case. Now, the important thing about Azora is that the court took its own advice and reminded itself that what it was concerned with was the forgiving of tax obligations. And they said that that was a decisive factor. And we can see that at paragraph 49. And indeed that precedes that with this, they review the different articulations of what level of unfairness is required.
So the degree of unfairness depends on the circumstances.
Exactly. And they said that what was important in that case was that there was a duty to collect rather than forgive tax. And then you can see that reflected in their conclusion at paragraph 52. It's necessary for Azora to show a high degree of unfairness arising in its particular circumstances in order to override the public interest. And in that case, from the other cases in the authorities that deal with consultation, it becomes clear that they are all uniquely fact sensitive. So if I can just mention them, Shaw is at tab 27, and we can see how it's determined by the facts of that case at paragraphs 101 to 102. Similarly, Baker was at tab 30. That's very fact sensitive at paragraph 81. And then, for example, again in Evie, I think it's a case in which my Lady Justice Laing was in. That's at tab 37. The key feature there, which we can see at paragraph 81, was the thing which was sought, about which consultation was sought, was a strategy rather than, and we say that's clearly distinguishable from our case. But it's perhaps worth looking at the last one that we have, Better Streets. Sorry, I'll give myself a tab number for that. That's behind tab 38. It's a decision of Mr. Justice Laing, and I'd invite your attention to paragraph 55. And it touches again on the way in which different judges tend to articulate the test in different ways. I just invite you to read that paragraph.
So which paragraph? 55?
Paragraph 55, please. So where does all of that take us? We say that the sort of unfairness which is required to found a duty of consultation is not wholly defined by those four categories in Plantagenet. That would be to treat it as a cage rather than a guide, contrary to the injunction of Lord Justice laws. We agree that the unfairness necessary to found a duty of consultation must be more than ordinary unfairness, but it is going to depend on the facts of the case. So while the case law identifies factors which have been relevant in those cases, as the Court of Appeal advised in Azora, the court should be cautious in simply adopting one factor from one case and applying it to the next. Finally, we say the touchstone for determining whether consultation is required is what good administration requires. And if a judge fails to take this approach to the question of whether or not there is a duty of consultation, then it amounts to an error of law or reasoning which may found an appeal. It's not simply a challenge to the judgment on the facts. So if I can invite you now to turn up the judgment and the way in which Mr. Justice Choudhury...
I'm so sorry to interrupt. So you rely on the judgment of Lord Justice falls in Batten Murphy for that proposition that you've just articulated, do you?
Yes, and that reference back to good administration appeared also in the judgment of the Supreme Court in Finucane at paragraph 59.
Which tab is that, please?
Tab 21.
You haven't yet referred us to Finucane. Did you want us to look at that?
I'm very happy to go back to that, lady. I'm just very aware of.
No. Well, I mean, we can always read it later if you're not.
Well, can I leave it at that? But if the question is Lord Justice Laws the only person talking about good administration, the answer is no. We also that's certainly one other place, and there may be others as well, but that's particularly a distinctive one, my lady.
It's not a very easy principle to apply in practice, is it? I mean, how is a court in a position to know what good administration requires?
Well, my lady, one might say that conspicuous unfairness is just a difficult question, isn't it? I'd say that something adjectival is perhaps necessarily difficult, but that is how the law works.
All right, so you're not relying on conspicuous unfairness, you're eschewing that.
Well, my lady, I'm saying that conspicuous unfairness is, as I said, a guide, but not a cage.
Right, okay.
So if, for example, you see conspicuous unfairness, then that is likely to found a duty of consultation, but it's not the beginning and the end.
All right, and do you say that this is a conspicuously unfair case or not?
We do say it's conspicuously unfair, but we say we don't need to go that far, and it would be wrong to use that test to shut us out.
Sorry, just let me get a note of that. So we do say conspicuously unfair, not need to go that far.
Yes, because we say we are there's a constellation of factors, and conspicuous unfairness is only element 4 of what is in paragraph 98(2) of Plantagenet.
Thank you. Sorry to keep interrupting. I'm just trying to understand the issue, and I'm very slow.
Not at all, my lady. I'm conscious of the need to get through the material.
Sure, I understand that.
So, can we turn up the judgment? We have it in the core bundle behind tab 13. It starts at 161. And then if you look within it at page 241, there starts the discussion of the consultation ground. And then if you turn to paragraph 198, and the way in which the judge approaches it, he starts with Plantagenet. And he says, the circumstances in which a duty consult can arise were helpfully summarised. And then he sets out subparagraph 2 of 98, the 4 main circumstances, and then that proposition, absent these factors, there will be no obligation. And then he sets out some, but not all of the other subparagraphs, and in particular, he misses out subparagraph 8, which is the subparagraph which relates to the promise as to procedure, which I showed you a few moments ago. So he treats Plantagenet as his starting point, and we say that he then goes on to allow it to cage rather than guide his analysis. If you go on then to paragraph 202, having been taken to Moseley, he says, Moseley can't be read as if the demands of fairness will always or generally or even more often than not impose a duty to consult. Such duty will arise only in limited circumstances, such as those where a failure to consult would give rise to conspicuous unfairness, or where there's a legitimate expectation or established practice of such consultation. We say that second sentence, in the light of the authorities I've shown you, is far too narrow.
Well, he says such as. He's not saying in black and white you have to have A or B. He's saying it only arises in limited circumstances. That's right. Isn't it?
That's right, but my lord, the difficulty is that he then only considers either Plantagenet 98.2, 2 or 4. He doesn't approach it on the basis of looking at what fairness or good administration or any of the other concepts require. He treats himself as looking very narrowly. So, for example, there isn't any consideration of taking all the factors together and whether that might be important in this case, as he was asked to do.
So that you did submit to him that it wasn't just a question of ticking boxes, you had to look at all the factors together.
Yeah, we asked him to look at all the factors together and not look at it too narrowly. So he says that the range of circumstances that might be regarded as conspicuously unfair is not limited. That's true, but of course conspicuously unfair, as I've said, is only one subparagraph of another subparagraph in Plantagenet. And then at...
So is his summary of Moseley correct?
Yes.
202. Do you quarrel with what he says about Moseley?
No, it's certainly true that fairness in itself, but the question is to look at it on the facts. I'm not suggesting that fairness will always require a duty to consult. The question is whether in those particular circumstances it arises and what one treats as a guide to looking at those circumstances. And we say conspicuous unfairness on its own, in this case, was too narrow. So the one example that he gives is Rainbow at 203. And he then says at 204, having looked at Rainbow, there were no statements that could generate an expectation of consultations. So, for example, he looks at the document that I showed you that promises involvement. And then he says, well, that doesn't on its own give rise to legitimate expectation of consultation. And obviously, on its own, we don't quibble with that. The difficulty is that it wasn't looked at in the light of all the other factors. It was simply excluded on that basis. And once it had been excluded on that basis, it wasn't looked at again in relation to the other factors. Then he, at 206, he looks at the abruptness question. But of course, it wasn't said in this case that there was abruptness, but it was there, having appeared in one case, elevated as a sort of indicative factor, at least, if not a necessary condition. And then at 207, he looks at the way in which the decision-making proceeded. And if I can invite you to recall the documents I showed you at the beginning of the afternoon, my submissions at 207, the documents which I showed the court then, he says, he accepts, gave the impression of finality. However, he then says, well, they look like that, but at 209, these references were not necessarily inconsistent with the decision being only in principle at that stage. And we say that was a strong construct to put on the material which I've shown the court today. Now,
What do you mean by that? Are you saying that actually that's not an interpretation of those documents that he was entitled to come to?
Milady, we say that where the government was making a decision of that magnitude, the contextual factors, then it ought to have consulted. So, and we show you.
So my lady's asking you a different question, which is whether your submission is that the judge was not entitled to reach that decision on the basis of the material in front of him.
That it was an in principle decision at 209.
We say that that was an error, but it formed part of that. What we can see about decision making was one of the contextual factors on which we rely to say that this was not good administration and there was a duty to consult.
So to turn it round again, you are saying, are you, that he wasn't entitled, looking at those documents and that document, to conclude that it was only an in principle decision?
We say it was an error, but we don't rely on it in order to make our appeal. We show you those documents, Milady, as part of the constellation of contextual factors to show the way in which the decision was made and that it didn't match up to the requirement of good administration.
So it's an immaterial error. Is that what you're
No, we
saying?
don't say it's immaterial. We say it's part of the picture.
How do we decide, how is the judge expected to decide what good administration requires? When Lord Justice Laws uses the phrase in Black Murphy, I think he ties it to a particular example of when a body a public body has said that it will do one thing and then does something different. But if you divorce it from that and just treat it as a touchstone, what does good administration require? How is the judge meant to know that?
Well, one of the things which is advanced is the need for transparency. We say that this wasn't a transparent process. And we also said, and of course, the law of consultation is complete with references to the need to consider what others say in order to make a better decision. And here we say that there was no consideration, conscientious as it was required to be, of what was said in order to make a decision.
I mean, what I'm thinking of is paragraph 30 of Black Murphy, where Lord Justice Laws says, it arises, that is unfairness or abuse of power, because good administration generally requires that where a public authority is given a plain assurance, it should be held to it. Now that I understand entirely. That's a general principle arising from the giving of an assurance. I think you want to use good administration as a much wider concept, the sort of thing which public bodies ought to do based on what you call a constellation of factors, the magnitude of the change and the promise that people would be engaged and involved and so on. And I'm just wondering whether that is really what Justice Laws meant when he's referring to good administration, whether he's explaining why public bodies that give assurances shouldn't be allowed to go back on them.
Well, another example is that which was said by Mr. Justice Laing in Better Streets at paragraph 55, which is something which goes beyond the behaviour expected from a public body. Now, I agree that these are nebulous expressions, but I'm not sure that they are any more nebulous than conspicuous unfairness. I understand it all, but I've shown you the authorities just to show just how varied the articulation of the principle is. But a key point for us is that conspicuous unfairness is not the beginning and the end of it. Conspicuous unfairness is one basis upon which the duty to consult might be founded, but it is not the only one.
But the difficulty is that the more shapeless this concept of good administration is, the more that it's up to the judge hearing the case to decide whether it meets that standard or doesn't. And that makes it more difficult for us to interfere, not less difficult.
Well, in this case, we say you can interfere because the judge didn't correctly direct himself. He was looking for, on his account, conspicuous unfairness, and we say that was.
Well, I wonder if that's fair to the judge, because we looked at what he said in 202.
Where he, for example, he doesn't direct himself into subparagraph 8, paragraph 98 of Plantagenet, which is the procedural promise. So what he does is he looks at the promises of involvement discussion. He says,
but he doesn't need to do that because the 4 bits that he did refer to right at the beginning do include a promise.
but of consultation.
Yeah.
But he says if you haven't got a promise of consultation, then you haven't got a material promise.
Right.
And we say if you've got a promise of involvement, discussion, engagement, that is still a material promise in relation to that thing. And if you read it together with your context.
Why does promising one thing oblige you to do something else? I mean, the whole of this argument proceeds on the basis that consultation, a promise of consultation, is a recognised thing. And it's explained what it actually requires in the Gurkha case. And that we don't have an express promise of consultation in this case. That's what the judge says, and I don't think you dispute that. We have a promise of engagement and involvement, which is something lesser. And why does a promise of engagement and involvement generate an obligation to consult? Why, by promising one thing, do you become obliged to do something more onerous?
Because of the contextual factors, and I say what's wrong is to say, well, you haven't got a promise of consultation, therefore that drops out. That's the error. If you've got a promise of involvement, that is still something important which falls to be considered together with these other factors.
And other factors can convert a promise to involve people into a promise to consult informally. Is that the argument?
Yes.
Right, we get a measure that.
And it's wrong to silo them and then say, well, you haven't got X, therefore X falls out of the picture for consideration. What you should say is, if X on its own isn't enough, that doesn't mean you stop considering it as part of
Can
the
you
picture.
show us an authority in which a court has adopted that analysis? In other words, there's been a nebulous promise of involvement and various other things, and the court has held that converts the promise of involvement into a promise to consult.
No, my lady, I can't. But what I can show you
Right?
are the cases which say this is intensely fact sensitive.
But
and
what's intensely fact sensitive?
The question of whether a duty of consultation arises.
If it's fact sensitive, I'm going to go back to a point I made a moment ago, which is the judge doesn't just say it's conspicuous unfairness or nothing. He says at 202, limited circumstances such as conspicuous unfairness or legitimate expectation. That's not exclusive. That's not, I can only do it if X. And then again, at 213, once he's been through all the analysis, he says, I conclude there was no duty to consult, whether as a matter of legitimate expectation or fairness or otherwise. So he's not confined himself to A or B. He's looked at everything that he thinks relevant. Now, if it's a fact-sensitive decision as to whether he thinks a duty to consult was generated, why do we not defer to his assessment of the facts? That's what's troubling me. When there's no clear legal standard which you can articulate beyond saying it's unfair, but the judge has decided that it's not unfair. How can we interfere with that assessment?
So, my lord, his starting point is Plantagenet. And he looks at it through the prism of Plantagenet and the 4 circumstances, and which we know says, absent those factors, there is no obligation. So that's.
Well, I would understand that argument if he said, look at Plantagenet, there are only 4 circumstances in which there's duty to consult. this is not A or B, and I'm satisfied it's not C, therefore no duty. But he doesn't quite do it in such a black and white way.
Well,
he looks at everything that is put forward and says, I don't think this was unfair.
Well, what he does is say, well, we're looking at Plantagenet subparagraph 2, 2 and 4. So subparagraph 2.2 is promise of consultation. He says you haven't got a promise of consultation, drops out. And we say that's wrong because if you look at Plantagenet subparagraph 8, it's an undertaking as to procedure. Furthermore, it engages these concepts of good administration, which I say are no more nebulous than conspicuous unfairness. He should have considered it together with the other factors. What he did was look at things individually. If a factor wasn't enough on its own to get us a duty of consultation, what he didn't do was consider all the factors together, and he didn't look at the particular character in the way that the Court of Appeal said we should in Azor, and said, well, in Azor they said, well, the important thing here is that this is a case about tax, and the important thing is not to forgive, to collect tax, not to forgive it. And what he ought to have been saying is, well, this is a case about pensions and the McCloud remedy, what ought to have been happening here. But he didn't look at it in that way. It was narrow and siloed.
But wasn't all of that self-evident from the rest of the judgment?
Well, Milady, the difficulty is that in all the other cases that I've shown you, the court self-consciously says what we're all dealing with here is X. What's important here is X. But that's not the way in which Mr. Justice Choudhury approached the question of whether an obligation arose in this case.
Is that a convenient moment?
It is.
Thank you. $10:30.
All right.